It's totally crazy to me. See, there's the,
Oh, the road,
The road.
It's gonna be.
yep, so they agreed to that,
Okay.
because that was in the development agreement, but that's the road at 3000 South. And I think what facilitated this light is because of the school down in Charleston. The new, what is it? Soldier Hollow is right on 3000 South, and that,
That's a huge mess.
yep,
Anytime schools
Yeah.
starting or ending, don't go that way because you'll be standing or just parked there behind the
Yeah.
line for.
Oh, the
Half
school
an hour.
across from Sage Creek,
yeah,
the horse place.
yeah.
Oh.
Yeah, it's been quite contentious for the council too. They ordered a bunch of signs and the school was gonna pay for them. They had them, the school would pay for them, and they're like, we're not putting them up until they pay. And it's been a contentious issue down there, but schools, as we know, can go anywhere they want.
Yes, they can. Yes, they can.
So you're not allowed to tell them where they can go. Do you have any other questions that,
So that would be your, just stick to the facts,
well,
as best we can.
you form your opinion, everybody has an opinion.
Everybody has an opinion.
Back it up with something. That's the idea, is just back it up with something that makes, so you're tangible to have that on.
Thank you.
Ends up being, my opinion is the code says this.
That's right. My opinion,
So,
my opinion, the
I like
code
that.
says this. Okay, so I didn't want to bother you guys to death, but hopefully that's helpful information.
That
Eric,
is, that's
there's
good.
those trainings that we go to, how do these guys find out about it? Because they're really informative, they're great to go to. I've been to a lot of meetings with Eric. So how do they find out to go to these trainings?
So a lot of those come in email. The government trust has emails they'll send out of trainings. YouTube, every training that's held is held on YouTube. So they put them right on YouTube. You can go in, click on YouTube, put in David Church, you'll get a whole list of, and you just pick your item. I mean, it goes from conditional uses to, just goes down, all these things. And so, of course, that changes every year with the legislature. They meet, they change the rules, so the new training takes place. That's why I keep going, because I keep learning new stuff. So as soon as I quit learning new stuff, I'll quit going to those trainings, so.
But for someone who doesn't know anything about it, when I went a couple times, I was quite shocked. I mean, you don't have to know a lot. They teach you what you do for conditional use and why you need it. And it was, I thought, very informative, and they're free, and they're all throughout Utah.
Yeah, as every building permit that we do has a fee attached to it for training, so we have to send that in as we do. So this is the planner report. Things that have been going on that you're probably aware of. Let's see, did I give you planner reports? You have planning report, is that?
We've got.
You got commission.
Okay, that's the first one is the
No
seats.
planner report.
So
Oh,
It's interesting.
the seats have been reappointed. Those are,
Get out.
that was, I know Gary requested this to know whose seat was up. We reappointed under the
Yeah,
resolution.
but you reappointed before we could say we didn't want it.
That's absolutely true, we did.
There's a reason.
I asked.
Yeah, Mary asked.
I did, I asked.
We absolutely did. Thank you.
Thank you.
I did, I asked if you had said yes. Sorry?
It's fine.
But Eric reassured her, they know how to get off, they just say they're done.
There you go. That's how you get off.
Or you just don't come to meetings and then that clause in the code, removal. comes
So
into
you have a
effect.
copy of that, that shows you what the seats are and when they expire. And then here's the planning report. You might have more questions on it than you had on the other. We did do one resolution or ordinance prior. And we had to fix a name, we had one seat out of order. So we did fix that in our last meeting, so that's the corrected one.
So it says 2016 to 2020, so basically we signed up for another 4 years.
Yes,
Right,
it's
thank
a
you.
4-year term
I'm like, well, no, we're
on
gonna
a
talk about
2-year
this again.
stagger.
Got
So
it.
it's a 4-year term on a 2-year stagger.
Got it.
So you're not replacing your entire planning commission
every
Right,
time.
trying to, it takes a while to get up to speed
Does.
with everything that's going on, so you stagger those every 2 years
Okay, thank you.
on a 4-year term. Okay, does anybody got any questions on the planning report? As you glaze over that, I want to tell you about down on complaints. We have sewer and water problems in Storm Haven. We have a public hearing scheduled for the 3rd of February. We're looking at raising rates up there. We've had to pump it 3 times last year, the sewer system. And what's continuing to be a problem is napkins and wipes are going down in the community septic. And they're snagging and backing up. So we have to go in and auger. Goes anywhere from $1,000 to $3,000 every time we do it. There's 18 hookups on that sewer system. There's more on the water, but there's only 18 on the sewer system. There's just no way to run that without raising rates until they can curb their habits of what is going down. You don't put them in your septic, but the folks up there are reluctant to stop. So as a council, we looked at and just don't know what else we're gonna do. You have to raise the rates. And so the rates eventually will bring compliance or it'll pay for it, one of the two.
I forgot to mention plastic Q-tips.
Yeah, those are nice too, huh? They don't break down either. So that public hearing will be coming up. Also, on that same time, we have what is a gun sanctuary resolution that we're looking at in the town. Is anybody interested in reading that? I will send it to you. I wasn't gonna print it off because there's like 5 pages. But if anybody would like that, I can email that to you so you can read it prior to the public hearing. Anybody?
Yeah, I'd like to see it.
Yeah.
What
A gun sanctuary.
Yeah, gun
How
sanctuary.
does that tie in
I thought we already had one.
with your federal law?
So, and this will all be discussed at the public hearing, because there's a lot of questions with that. And
It's,
This is on February 3rd?
yes,
Okay.
could be a long
So you
meeting.
email it to me too.
okay, yeah, and I'll send it to everybody if everybody wants it.
Yeah.
I just didn't know who would want it. So what happened was, there's several states now that have decided that they're gonna outlaw multiple, well, semi-automatic guns, large capacity magazines, and they've actually this year, they passed those before, but it hasn't become an action item. This year, they've actually taken money and put into those bills. So there's actually money to spend to collect those. So it's like the bump stocks that we seen was outlawed a little while ago. If you had one and you didn't turn it in, you're a felon if you own that. So that's basically how the whole thing's gonna go. The new red flag law went into effect, and it's a federal law, and so there's been some reluctancy on how that's administered. So really, it's up to the sheriff's office that's gonna come out and either take your guns if they think you're a threat, or domestic violence, or there's several things that fall in that red category. As far as this item that we're talking about, it's just like the sanctuary cities for illegal alien.
What was it, what?
It's just like the sanctuary city for the illegal alien.
Oh.
So what that does is says, we're not gonna spend our taxpayer money and go out and do this because we think it's against the rights of those people, is what the sanctuary cities went. The gun sanctuary says we won't spend taxpayer money and prosecute for violations of our Second Amendment rights. So it speaks to that in there. The problem with it being, and this will come out in the meeting, I'm sure, is that the first thing you think of is, why is the town of Daniel interpreting the Constitution? That's what I thought when I got brought up. Well, we're not qualified to. So the gun sanctuary has the stuff in, and to back up that position are the Supreme Court cases in that document. So you're able to, what the town's doing is backing up the Supreme Court and their interpretation of the Second Amendment. So you'll see that as you go through there. It's quite a read. It's quite a right.
So who's pushing that? Just
it was just requested that we do it, and I said, let's put it in a public hearing and see what the feel is. We do have, there has been some confusion with guns being fired within the municipality, and people just thought once that your municipality that it's illegal to shoot a gun, which is not the case. That's a separate ordinance. So you all know that it's still legal to fire a gun in the city limits of Daniel.
But within a
There's still
distance of.
very-
there's still federal law and state law that you have to comply with.
Oh, okay, okay.
Yeah, but most, like Heber City, you can't discharge a firearm in city limits.
Period.
Period. So, you've seen the recent court cases, that applies to bows and arrows.
Really?
Yeah.
Even if they have suction cups on the end of the arrow?
I guess it depends on who you shoot with that suction cup.
I think
So-
that's a valid question.
So that's very good. Tom, do you want a copy of that also?
Yes, please.
Okay, I'll just send it out to everybody, including you. So we'll send that out so you have a copy of that. But I wanted you aware of that, so there will be a public hearing on the 3rd for that also. Any other questions on the planner report?
Just a couple questions on the planning items. The web application for determination of a building lot, they just are still trying to determine if they have a building lot?
This was actually a determination across the road where the Quonset hut is.
Oh,
So they came to us, on the other side of the road, they wanted us to make a lot. On this side of the road, they wanted the town to tell them it's not a buildable lot.
what?
Because of the taxing. Their taxes came out. And they called and wanted the town to say that that is not a buildable lot because it's not 5 acres. Well, that lot was built
Long time
a long time ago. So we actually told them that if they wanted us to say that, they would have to record a deed restriction against the property at the courthouse, then we would make that statement as a town. So as far as I know, that hasn't been done yet, but that's how we figured, with talking to Ryan, that's how we figured we could do that, was a deed restriction on the property, because they just want to keep their truck there, they want to keep doing what they've been doing with the trucking, and that was the only way that the town would, because really, we're liable, we go, yeah, it's not buildable, well, here we are in court, down the road, but if there's a deed restriction,
Yeah, but they'd still tax it as, or could tax it as commercial.
yes. But they are taxing it as a buildable lot.
I don't think
Commercial
that would
use
stop
has
it
been
from
buildable
being
lot.
taxed.
I don't think it,
They need to go to the assessor's office. I don't think that'll make any difference whatsoever.
they had been there, and that's what they told them. They actually told them, if you go to Daniel, they sign a paper that says it's not buildable lot, we'll drop the taxes. And so that was the report I got back. I said, well, if you want the town to do that, you have to do this.
Yeah, but according to what we've heard, then the county should tax it as commercial property because of the use.
It wouldn't even surprise me if it's already taxed as commercial, which is at 100%. It's not the reduced rate of primary residence, so.
Okay.
Yeah, I didn't look at the tax roll to see what it was, I just had the request, they called and wanted us to do it right away, because they are under the scope of time frame with the county for appeals. So I just told them, this is how you can do it, the town will issue a letter once the deed restriction's been recorded on the property. So I never got reported back, so, yeah, that was just same people, different sides of the road, so.
It's pretty complicated.
Yeah.
Sounds like.
We do have some other issues with non-conforming lots and lot splits that have been done without our knowledge, illegal lot splits, subdivision, illegal subdivision, I guess I should say. And we're kind of crossing those as we go. Kip Bangeter had his final inspection. He's almost ready for his CO, so he's almost got her done. Cool. So that's a good thing. I went to court on the Reader suit. I think we're getting ready to file for a summary judgment pretty soon on that one. You guys knew that Nathan withdrew his lawsuit to get out of the town. So if you didn't know that, he did, he withdrew.
What's he doing on that now?
Nothing, he hasn't done anything, he just withdrew. And he talked to me over to Tractor Supply, and he's like, I'd really like to do that, but I need you guys to sign the thing that says you'll supply. So you know what, we're not gonna sign anything, we think we got you beat, so we're not out anything, so.
So he's just giving up then?
Yeah, he's just giving up for now, so. Withdrew, and that's what I said, you're just spending good money after bad, it's yours. So that was our position, and so he just dropped it, so we're no longer in that lawsuit, he's withdrawn.
Was the other annexation dropped down close to industrial properties
The north properties
over by Beaver?
by the airport.
Yeah.
So we held the public hearing, we went through all the motions, we had several people come and did not want to be annexed, and we just haven't acted on it. So the public hearing's been held, we took the testimony, we've done a lot, we have a new Heber City Council now, that might change some things over there, along that edge.
Is that Coleman's property, Eric?
Yeah, the back of Coleman's little piece.
So none of them are doing anything either at this
No.
point?
No, and again, the town was initiating that, no, there wasn't an applicant, so it's a little bit different, as usually somebody would apply for annexation, and the town was actually doing that, and as I read through the state code on that, I don't believe we have to actually do an annexation, because at the end of that section, it says, none of this shall constrain two municipalities from drawing a common line. So that was my approach now, is to try and get Heber City to come on board, put the line in. The new manager for Heber City had actually plans to make all of that industrial out there, and then he found out it was in Daniel. So that kind of put the skids on that, but that was where Heber City was planned.
So there was never a lawsuit filed over that?
Yeah, there was.
By the other parties?
Coleman's did, didn't they?
No,
With, okay.
no, there was never any.
I think they were considering it, but.
He was, and that, in the last meeting when he come, he says, you guys changed my zoning, and I says, I dare you to show me. Show me where we changed the map since we became a town. Because that was his claim, and he kept making the claim, and I'm like, show us where we did that. Because I've been there the whole time, I haven't seen any of that change. So I think he went and did some homework and found out the county made that line, we never did, that was prior to the town.
Well, I thought Attorney Gordon was pursuing that.
No,
He was just here at these meetings and talking about it and never pursued it in court?
no.
Okay. Wow.
Yeah, when he was here, I think he was representing,
Nader?
yeah,
Yeah, okay.
so I think it was just talk about. But I think once they did their homework, they found out we haven't done anything. We haven't changed zoning, everything's the way the county had it, so.
In a broader sense then, what's gonna happen down there, do you think?
I don't know. I don't know, there's conflicting codes, state code, because we're close to an airport. You can't annex next to an airport, another municipality, that's why, because it's so complicated that I think if we come to a common ground, it's a way to fix it and be, I mean, the Andersons absolutely want to not be in the town, Kate and Eric.
Mm.
They don't want to be in the town. She's made that very clear.
Well, I thought Scott and Melanie said that too.
Well, the problem with Scott and Melanie is only 5 acres is out, the rest of the property is already in the town.
Oh, okay.
So, what that line did is it cut parcels in half.
Yeah,
And so that's what they're talking about, is half the parcels in the county, well, it's 300 feet is in the county. The rest of the parcel is all in Daniel already. So, as a town, if we annex property, we have to annex the entire property. When the county made the town, they just drew a line.
so the part of Coleman's property that is in Daniel, what is its zone?
It's RA5.
So it's not their industrial property to begin with?
No, there is some industrial in the back into that, but everything up on the front is RA5.
Okay.
So the back of that, as a matter of fact, our map will show that. The gray area that you have there, Pam, I can underline mine. That gray area in the middle there is all industrial.
Okay.
And so that was done at the county. That was the county zoning, happened in 2002.
What's this?
It's the part that's in the county still.
Oh, that's the part that's in,
Yeah, so that's,
dispute or
That's the no man's land.
discussion or
well,
no
it
man's
split the
land.
parcels. And so what it did by that is it created an additional tax number on the parcel, because now they're being taxed as a county. Daniel has a different tax rate. So it split those properties. So some of those properties along there have actually sold the other lot.
Like the gray area,
Yes,
I see.
because
Is that-
it shows up as a separate parcel.
Is that possible to do?
They've sold it.
Did.
Well, because that's what they did to my property too. And every time I go to the bank or anywhere else, everybody says, well, you've got 2 parcels. No, I don't, I've got 1 contiguous parcel. Well, no, the way it's written down here, you've got 2 parcels. You go in and talk to them, and they say, no, you still have 1, but anybody at the bank or anybody else who, they're thinking that that's, and it's an enormous, enormous problem.
Yeah. Yeah, and so he was really close to fixing that last year at the legislature. If you change a lot, you have to get a signature from the municipality. So if somebody was to take a 5-acre parcel and cut an acre off, they'd have to get a signature from the town or it would have been illegal. That's what they almost passed, it didn't pass last
But
year.
the property owners never did that.
Never did.
It wasn't the property owners that split off the second parcel. It was the taxing commission that did that.
You're right, right.
And when I first found that out, I went in and asked, I said, does that mean, because I've got 2 acres out on the front, and then the rest of mine goes back and up the hill. And I said, does that mean I can sell these 2 acres? And they said, oh no, you can't sell that, it's all still 1 piece. Well, how come the bank doesn't recognize it as 1 piece?
Yeah,
Because they won't make me a loan on the entire piece of property that I have, they'll only make me a loan on the 2 front acres.
yeah.
And
Yeah.
so,
It's an item, it is a problem.
well, at that point, then, what has to happen is you're gonna have to get a lawyer to go in and put an action against the bank for not recognizing what the tax commission said.
Yeah, yep.
And that becomes very expensive and all of a sudden a huge burden on the property owner. It was never the property owners that started this.
Yeah, and we have the same thing, exact same thing when they split the parcels, which is why the law says you have to take the entire one, unless the property owner signs off. There's a clause in there that if they want to peel off part of their property into it, but,
How many parcels are there like that in the town of Daniel?
gosh,
A lot.
yeah, there's a law.
6, 7, 8.
And is this something that the property owners are saying anything about, or are they all
Well,
just-
we've had some along Daniel Road that actually sold the back parcel.
So if that's been done, what's to stop anybody else from doing it?
And well, those back parcels now there's no access to the road.
They're worthless.
There's no, it's a lot in the back. Actually, it's illegal law.
Well, if you sold it to the people who own property next door to you,
They may have access out that way, but
Yeah.
if you just bought that 2 acres in the back, you'd be hosed. So we have that along the highway corridor. Access was off Little Sweden. They split their field, split 5 acres off. It's a legal lot, just doesn't have access. There's no access on that limited highway.
is there anything the town can do to stop that from going on?
Really, it falls on the realtors. That's the only policing you can really do. Is that right, Ryan?
Pretty much, with the current code, the state code, you can record these parcels without the municipality. And-
Right, but the
And-
municipality can still say you can't build them, right?
Yes, but you have to, which is why we've had applicants come in and we say, show that it's a legal lot,
Yeah.
because,
Stevens?
and I've talked to the county recorder about, would you stop recording these things without the town's approval, and the problem is state law prohibits that, she has to record it. And so, you know, it's a huge problem for the county too, they don't like it, but they can't stop it.
So there were a couple on Little Sweden you referred to, is that, where are they, whose properties are they?
I can't say.
Oh, okay.
So when Twin Creeks did their assessment, that was where one of those lines got drawn.
Who
So
was it?
when the Billy Weather system became part of Twin Creeks, there was a bunch of parcels created there for the taxing of the Billy Weather system. And so if you look, there's a nice straight line all the way down that's offset at Little Sweden Road. I can't remember the amount, some 200 feet, 500 feet, something like that. If you look, it created a bunch of weird remnant parcels, but when you look at the surveys, you realize it's the one lot, 2 lot scenario. And so that's happened there, and then there's other folks that they've just carved out a lot, carved out 1 acre as a legal description, one recorded it, and it shows up as two parcels with 2 tax
Oh,
IDs.
okay, but that's different than the taxing commission coming in and splitting off somebody's lot without asking their permission.
They are 2 different scenarios, they look very similar on the map. As
Sure,
far
sure.
as the town trying to decide if it's a buildable lot or a real lot, it looks,
But
it's the same problem.
Really, that's the same. If a special service district comes in and draws the line, or the taxing commission, it's the same thing. The owner didn't do that.
Right, but what I understood you to say was that there were owners that went in there and divided off 2 acres and did that.
We do have that, and some have been here. The Huftel property that came, they
Uh-huh.
wanted to sell part of it. It was an illegal split.
And that's down by,
That's in the back, Big Hall Road on the left-hand side.
by Roses down there?
Mhm.
Okay.
So they peeled off 2 acres? I forget now. They peeled off some acre where the home size is, and then had the rest of the property, and then they wanted to sell. And they come here to ask us, and we're like, it's an illegal lot split. We can't.
But they actually accomplished that? I thought that they were stopped from doing that.
The guy that bought it, bought the entire property, but it shows up as 2 different parcels on that map. It'll show us 2 different parcels.
So, Eric, if there's an existing house on that 2 acres, and they sell it, what's to stop somebody from doing that? You have to have 5 acres if you wanna build, but if you're happy with the house that's on there,
Right. Well, that's why I say it. The only recourse is the realtor. They'll go after their license for selling, not doing their due diligence, and selling an illegal lot. Which we have, I can tell you that weekly I get calls about lots that are 1 acre and a 5 acre zone that have been peeled off a 10 acre parcel or a 7 acre parcel or.
and do they still go through, or are they prevented? Are they stopped?
So far, when the bank does their due diligence and calls me, and the second I say that's an illegal subdivide, they're done talking to those folks. Because they're not gonna.
The bank won't finance it,
Right, the bank will not finance it.
but if you're dealing with a
If you're dealing with the cash
cash
buy.
customer.
Yep. So we just saw that on the Myrick property. We just saw that on the Myrick property. They cut the back acre out. And so we said, well, that's illegal lot split. Didn't matter, it was a cash buyer.
So-
Didn't have to go to the bank.
So is there anything the town is planning to do about that? Should we be planning or looking at it at least, or?
Well, eventually, somebody's gonna buy that acre and wanna do something on it. And that's when it's an illegal lot.
Okay, but I'm not talking about that specific, I'm talking about that general problem in Daniel.
Again, I think the legislature has to tackle that. They know it's a problem, but there's a lot of developers that sit on the legislature. A lot of lawyers, and I think it's hard to get through. But it's not our problem, it's statewide. It's happening all over. So it's not just a Danville problem, it's everywhere. And it's a simple fix. The municipality has to sign. There you go.
If what? Say again?
If the municipality has to sign when you do a lot split, if there's a signature block that they have to sign, that fixes that problem. It'll comply with the zoning ordinances that are in effect wherever that is. If they have a signature block.
So the problem isn't that, I mean, we can still tell them they can't build, but people that need protection are the ones that are buying it, that they bought it and now 10 years later, they think it's been their dream for 10 years to build, and they come in and we say, sorry, you can't do that.
Which is a twofold problem, because now what do you do with 1 acre?
Right.
Yeah.
That's sitting there full of weeds, and there's a blight. So it's a twofold problem.
Well, I just wonder if, as a town, we ought to put some thought into that. Is that something that concerns us as a town? It seems to me like it should.
So it does concern us, but there's really nothing we can do if they're required at the county to record that. They're not calling and asking our permission.
I have put considerable thought into it. I don't have a good answer. We've done a lot of good and a lot of work at catching them. So when people come in with non-conforming lots, trying to get answers for how was it created, when was it created, you're in this boat or you're not in that boat. I've done some fairly good, we made headway there. As far as stopping it, I mean, I called realtors and said, do you know what you're doing? And I thought that was a great answer. The problem is that realtor disappears and there's another realtor the next day. And so then, I mean, unless you're gonna stay on top of it for ever, and then if you stay on top of this one, but you missed that one, was that fair or was that, I mean, that becomes a challenge. So other than making sure that we've been able to identify them so that we don't issue building permits, I don't know what else we can do until, like Eric said, it's a simple fix. Let the municipality, the land use authority have authority over the land use.
So I know of at least, I would say probably 10 people that have called and talked to Eric before they ever bought and asked, said, hey, I got this, what do you think? And Eric said, this
You're
is
gonna be
what's
so
going.
excited you've done your due diligence.
Yeah, and then he
That's what I
tells them
tell
this is the problem, and they go do it, they buy it anyways, and then they come in front of the council and say, we want it switched. And we didn't know this, and Eric, I says, why do you never say, I told you, you called me. I told you this was the way it is, and now you want us to, well, you guys can change it. It's just quite interesting to see, there is some out there that they don't care what you say. They believe they bought it, they can do what they want with it.
The other one I've seen is the 10 people call, and we tell 10 people what we see, and they walk away.
Yeah.
And the 11th person doesn't do their due diligence, buys it, and then it's the city, it's the town's problem that they bought a lot that it has problems. And, the 10 people you helped and the one you didn't, and what are you supposed to do?
I got a call this week on Blaine Smith's house. Eureka, the lady's excited, she found this house, has a perfect answer. There's a house on this half, we're gonna subdivide it and put another house right there. And it's perfect. I said, well, that would be an awesome thing, and it looks like it's all set up for that. But you have to have 5 acres. They had no idea,
What'd she say?
not interested.
That killed the deal.
Yeah, yeah, if you could subdivide it, build another house and sell one of them, you've almost got a free lot. I mean, the Eureka, she had it. Dang it, zoning. And I get those all the time. And they've just found the loop, here we are, we've made it.
Found our dream.
There it is, got it. So I get those all the time. I'll bet at least 2 a day. And I don't know how many your office is fielding.
Comes in waves.
So if they go to another municipality, Heber or the county, they give them my number.
Well, that's another problem. I mean, they'll call Heber and ask them what they can do in Daniel, and sometimes Heber answers.
And the county does it too. I mean, you've seen the letters from the county. If this was in the county, it'd be fine. It's like, whoa.
I think the biggest problem though is like they said, they go just cut these pieces off, these parcels, and then they have a tax ID number, so people think it's got a tax ID number, so.
The bank goes by that.
Yeah,
only.
it's
I have
legal,
tried to get
and
the
it's
bank.
not,
And they're not.
Yeah.
The bank says, no, you do not have
yeah,
one parcel, you have 2. It's
Yeah.
that, this is a tax number here, and this is a tax number there.
yep,
And you say, well, look at the fine print on the bottom, and it says, do not use this for determination of the lot size. They're all part of the same contiguous piece. The bank will not at all.
exactly, and that's what these people are coming, they're showing, saying, I got a tax ID number, it's legal, I got a lot, and you guys are saying, no, it's not a lot.
This means you have to pay.
Well, the thing is to make them understand that yes, you have a parcel, you don't have a lot. So you have a parcel, but you do not have a lot.
Well, technically, from the taxing entity down here, that's not what they say. They say you have 1 parcel. There's 2 separate tax identification numbers, but it's for both of the same parcel.
See, and for a long time, Wasatch County, if you had 2, they were merging them without the owner's consent. So that went on for quite a while. There was quite a few people that was upset.
Oh, yeah.
That had been through the process of dividing,
Yeah,
and then all of a sudden it was one
put
parcel.
it back together again.
Yeah, so now we have different codes, different regulations, and it's just a huge thing.
Have any of these people talked about going to court over this?
Every one of them.
Have any of them done it?
You know, I don't know. I haven't really followed anybody's courts but ours because I've been kind of tied up with ours, but I don't know. I don't know that anybody's pursued that avenue. Have you heard anything, Mary, along those
No,
lines?
it's a problem all over the county though, I know that.
Yeah.
Because I think that would be a real, potential for problem. If something goes to court and the judge agrees with these people and they're told, well, yeah, you've got 2 parcels and there you go. Would we still be able to tell them, no, you gotta have 5 acres?
Yeah, absolutely. You still have to conform to the zoning.
Even if a judge says not?
Just because you own a parcel doesn't mean that you can qualify for a building permit. If you don't have the frontage, you don't qualify. Even on these 1 acre lots, we have a lot up in Storm Haven right now that's being sold, and the lot itself is 108 feet wide. And so I'm telling them, this is your setbacks in the RA5. 10 feet from each, 30 feet from the edge of the road, or 60 feet from the center, 30 on the rear, and it's like, I can't build on here. You still have to meet the setbacks. So just because you have a lot does not guarantee you a building permit. The zoning regulations still have to be met before we can issue a permit.
And what's our frontage requirement right now?
So, in the RA5 zone, it's 30 feet from the edge of the road or 60 feet from the center, whichever is greater. So that's how our code reads.
You asked about frontage, the frontage is 100 feet.
100 feet.
Oh, for width?
Right, right.
You're right, we have 100 feet of frontage.
So if they had 108 feet, and that was all we were looking at, they'd have 8 feet more than that 100-foot requirement.
Well, recorded subdivisions actually fall under 822, which is a separate code. So we ran into that with the plumber, high plumber subdivision. And so there's a little bit different tweak on those. That does speak to some of the setbacks on a pre-recorded subdivision.
Mhm.
So some of that does not apply.
Okay.
So of course, 821 supplemental standards does apply to that. But the 822 is written specifically for subdivisions that were recorded prior to the zoning. So,
Interesting, thank you.
yeah, a lot of information nobody wanted to know.
I'm waiting solve.
Okay, any other questions on the planning report? Everybody satisfied? Okay, I will send that out to you guys. So you have that, and again, that meeting will be on the 3rd. So if you want to come out to the public hearing, it's your chance to talk about it. There'll be a lot of information, so. Okay, that takes us to minute approval, item number 6. For October 16th, 2019, has everybody had a chance to review those? And are there any corrections or additions?
There's a couple corrections, just grammatical periods and stuff. Did you catch those already?
You know what?
You didn't do them, that's right. Mary did them.
Yeah, I just set them on, so I can go back through and look at them.
Okay, there's just sentences that run together and things like that.
Okay.
That's how I talk.
Mhm.
That's how I talk.
Well, but you're not written down here.
Oh, that's too bad.
And then, and I can show them to you after. Is that appropriate? So we
No,
don't
they
take
need,
time?
if you have a
Oh.
correction, you need to give her.
Okay, so under planner report, the second one says, meet with the developer in reference to property along Highway 189. They are looking to possibly annex to the town. Should be a sentence change there.
Okay, what section is that in?
The planner report,
Uh,
you have the minutes.
I don't have any with me, but.
That'll be hard
Just
to
take your
figure
pen
out.
and write those ones if you can leave them with her.
Yeah, I did. Okay, I can leave them with her.
Okay.
And then the next one is, starts with Ryan Taylor, and it's also just a sentence problem.
Okay.
And I'll show it to you after. Is that okay? Just give her my minutes?
Yeah, yeah, if you have
That's
those. Is everybody aware of those changes?
those changes.
Okay.
Just small. And then my only request is on our minutes, and I'm gonna pay a little more attention. These I realize are October 16th, and as I read through them, they really didn't set any light bulbs up with me of what the heck we talked about. So maybe we can have a little more detail at certain times, a little, I know you didn't do these, so I'll just observe that on the next ones. That sometimes the broad statements that I'm seeing in the minutes don't give me enough information, and since they're pretty important. I know we jabber along a little bit, that's not what I'm talking about, but my example is meet with the developer in reference to property along Highway 189. They are looking to possibly annex into the town. That really doesn't tell me anything. I don't even remember the conversation. So a little more information on that kind of thing I would like in the minutes. Is that appropriate?
Do you want to hit that, Gary?
Don't hit me.
No, I'm just saying, that's planner report, and that's really about as much as we got.
Okay, all
I
right.
mean, that's not
It
something
doesn't
that
mean
we-
anything to me,
It's
but,
not something that we discussed.
Wasn't an
in the-
application,
An application or
So-
something.
just
Okay.
So
information.
that's just information that he gave us.
okay, so it didn't really tell us anything as I read this.
It's just a heads up of something coming down the turnpike like the Highway
Okay, all
40.
right, fair enough.
So like this
Those kind of
discussion
things.
about lots and stuff,
Yeah, yeah.
that was
Okay,
Yeah.
just a discussion.
just part of the planner report.
Okay. All right, that is all I have to comment on.
Okay, so do we have a motion?
I'll make a motion to accept the October minutes.
That's corrected.
With the
As
correct,
corrected,
with the,
as corrected.
with the corrections. Okay.
Okay, is there a second?
I'll second it.
Have a motion and a second. Any discussion on the motion? Seeing none, call for the vote, all in favor?
I,
Any opposed? Motion carries. You got Tom in on that vote too? Okay. All right, yes, if
Our
you will
stealth
hand that
member
to,
tonight. Our
Carrie?
stealth member tonight.
that will become our official one that will be changed.
okay.
Do you need this back?
Oh, you can have that if you'd like it. Okay, item number 7, motion to adjourn.
I move that we adjourn.
Have a motion, is there a second?
Second.
Okay, I have a motion and a second, any discussion?
Good idea.
Good idea, I like the discussion, okay. Call for the vote, all in favor?
I.
None opposed? We stand adjourned till our next meeting, February.